It's the home stretch. Damages. This is going to be review for a lot of you, putting the pieces together of all of the conversations that we've been having around remedies and damages during this course. So hopefully, as you go through this material, as you watch these videos, as we talk about it as a group, things will start to coalesce. What do we know at this point? We know that courts have a firm preference in contract for awarding monetary remedies. We've talked about this notion that on occasion courts will specifically order parties to perform or not to perform, to enjoin performance, but that is rare, that's not the default. As your textbook talks about, that could be the default in other jurisdictions, civil law countries. But here in our common law of contracts, the preference really is towards monetary remedies. So great. We've talked about monetary remedies before on a number of occasions. Now we're tying them all together. And the important thing, I think, for you to be thinking of strategically is one of these main types of monetary damages that we're going to go through in this chapter a better fit than others. We have discussed in the past that parties often like expectation damages because usually that will get parties the greatest sum of money in damages, but that's not always the case, and that's particularly not always the case when the expectation damages might be hard to prove or might seem to courts like they're going to lead the party to receive a windfall. And so what you'll be trying to do as you go through different scenarios and damages is think, what has actually happened? How have parties already performed or failed to perform under the contract? What can I prove in terms of damages? Or if you're on the defense, what can I argue the claimant cannot prove? Right? Too speculative. And how do all those pieces fit together in asking for these various types of monetary remedies? And so generally speaking, you are going to be seeking one of these types of remedies. So don't double count. They're not really additive. These are different types of calculations to get you at a figure for what you should receive as typically the non-breaching party under the contract. So we're talking about situations where the other party is in breach, you've shown that they're in breach, and you now need to receive your remedies from the court. So, as an example, plaintiff homeowner asked defendant painter to paint the house. Homeowner agrees to provide all the paint, which costs $1,000, and to pay the painter $10,000 for painting the house. So the owner expected to put out $11,000 in total for the paint job. If the homeowner, so let's say that's the setup, and for whatever reason our defendant painter just refuses to perform. Outright material breach. Let's say it's an anticipatory repudiation, says, I'm never coming to your house, don't expect me to see you there ever, I am not going to paint your house. All right. So now, if they had a contract, which we're saying that they did, now the homeowner can be thinking about remedies. Now let's say the homeowner says, okay, whatever, I don't really need my house painted, but they can't return the paint, the $1,000 of paint that they already bought. So now the homeowner is sitting on a $1,000 expenditure that they wouldn't have made but for the fact that they thought their house was going to get painted. Right? But they're not paying anybody else to paint the house. In that situation, reliance damages make the most sense, suing the painter for the $1,000 in paint that the homeowner had purchased and can't return. Now, if the homeowner can return the paint, then arguably this is sort of a no harm, no foul situation. The homeowner is out the sort of inconvenience and time of finding somebody else perhaps to paint their house in the future, but if they've made the decision as a homeowner, I don't need this done right now, and I can return the paint, then they're out a little bit of time it takes to have picked up the paint in the first place and to return it. Let's say instead the homeowner finds another painter to do the work, but the substitute painter costs $12,000, right, to do the work. Remember, they were going to pay the prior painter $10,000, right? But the homeowner, remember in our hypo, has already put out $1,000 in paint. So now the homeowner is out $13,000. The $12,000 for the new painter plus the $1,000 that they spent on the paint. But keep in mind, right, that under the original contract, right, that $1,000 for the paint was something that the homeowner was expecting to be their expense. So the total damages are $13,000 minus $11,000, or $2,000. Right? Another way you could think about it is you just don't even put that $1,000 for paint in your calculations, because the homeowner was going to spend that either in the original transaction or in the substitute transaction. So the only cost that changes is the cost of the actual performance by the painter. $12,000 minus $10,000, $2,000 damages. In expectation, either way, the idea there being overall for the transaction of getting their house painted, the homeowner is out $2,000 more than they expected to be under the original contract. Let's say that you had planned to buy $1,000 worth of paint with Painter 1, but you didn't at the time that Painter 1 informed you of his intent to breach, at the time of the repudiation. You did still have to pay the new painter $12,000, but that painter provided his own paint. All right, now you see where I'm going with this? Now it's a little bit trickier, right? Because you had expected to pay $11,000 under your first contract, $10,000 for the painter, $1,000 for the paint, and now in your substitute transaction, the new painter is providing their own paint. Right. So you could calculate this out sort of mentally a couple of different ways. You could just say, well, had to pay $12,000 now, expected to pay $11,000 total, $1,000 extra cost. Those are my expectation damages. Right. Or you could say, well, we're going to take the difference in the cost of the service, $12,000 minus $10,000, and also subtract that $1,000 that we were expecting to pay for paint to get to the same place, $1,000 of damages. And then finally, let's talk about a restitution example. You gave the paint to the painter. You gave them $1,000 worth of paint, and then they drove away and said, we're never showing up again. And let's say we're back to scenario 1 where you're like, well, I give up. I'm not going to bother trying to find somebody to paint my house. I don't trust painters anymore. But they still have $1,000 worth of your paint, right? You have conferred a benefit on them. They owe you $1,000 for that paint. Right. So the way that the scenario is set up, right, what actually happens between the parties can suggest that certain types of remedies might be easier to prove or more appropriate than others. So just a quick review of what I actually have here on this slide that you've probably been staring at for the last few minutes. So here are the 3 main categories. These are all categories we've talked about before. Expectation damages. The idea is to put the claimant, the plaintiff, in as good a position as they would have been if the contract had been performed. Right? And you get expectation damages typically when we're talking about a material breach. Now, frankly, a material breach could lead to any of these kinds of damages, but expectation is what typically flows from a material breach, is seeking expectation damages. And then we've talked about reliance damages, right, which is to put the contract back at point 0, to put the plaintiff in as good a position as they would have been if the contract had not been made at all. And we talked about those damages in conjunction with promissory estoppel doctrine. Many times, if you can't necessarily show, for instance, that there even was a contract or that the breach was material, you might still make a strong argument for reliance damages because you took certain actions under the contract expecting the other party to perform. Then finally, there's this restitutionary interest, restitution damages, and we talked about those in conjunction with unjust enrichment, right? And that is the disgorgement of the benefit. The plaintiff is given back any benefit that they have conferred on the other party. So what I want you to think about for class tomorrow is the hairy hand case, which we will talk about in class. If any of you feel the need to run out and watch The Paper Chase, it looks like it's streaming for about $3.99 on a number of services. I checked right before I started filming. We are also going to talk about Problem 20.3, which is another famous case about a nose job gone wrong. And I want you to reread that in particular. Read that carefully and think about which damages seem most appropriate in this case. And just to briefly contrast or compare more aptly Hawkins v. McGee and the Sullivan v. O'Connor cases, what ends up being articulated as something like the expectation interest is the difference between a good hand and the hand received, right? That's the hairy hand, you know. Good hand, no hair, versus hairy hand. Think about, in connection with that, how you determine that value. And we'll talk about it in our group discussion. The final case that I'm having you read for discussion is looking at calculating expectation damages. And so expectation damages can be broken down into a few categories, or a few, maybe a helpful way to think of it is inputs. Right, direct damages, right, which is what value the party expected to receive from the contract itself. Right? And this is often, as we have been talking about, as you'll see in the Hawkins v. McGee case, the value of what you expected to receive subtracted from, and you subtract the value that was actually received. So the idea here being you expected something better than what you got. What you got was substandard, subpar, right? And so this value in between is what you should get in direct damages. Great. But then, in expectation, there are certain things that flow from the breach, right? And the big categories here are consequential damages, which we'll talk more about this chapter, and incidental damages. So it may be that if you are, let's go back to Sullivan v. O'Connor, if you're a famous actress and because your visage has been irreparably damaged, you can no longer get parts, right? Is that something that you can claim as a consequential damage? Again, something to think about as we talk about problem 20.3. So a consequential damage is something that is said to be a result of the defendant's breach. Right? So plaintiff either doesn't get to engage in some future activity that was going to get them money or some sort of benefit or value, or occasionally, and you can imagine this very much being the case in, say, something like a supply chain, the person who's in the middle of the supply chain is expecting to get something from their supplier, and then once they receive that, they can then go and maybe put that into a good that they're going to sell to somebody down the line. Right? If the supplier fails, right, then obviously this middleman is going to be liable down the chain to their buyers. Right? That might be an example of a situation where you're going to potentially suffer a loss because you could be sued because your supplier, or it could just as easily be a service provider, because your service provider didn't provide the necessary services. Perhaps think of this in light of our Milburn v. Needle case, where the funeral home subcontracted for a service for the watcher, the chaumarim, over the casket, and the chaumarim didn't show up, and then the funeral home didn't get paid for that funeral. And ultimately, that could arguably be a consequential damage that flowed from the result of the watchers failing to show up. And then we have incidental damages, which are the plaintiff's costs of coping with the breach. Right? It's not necessarily going to be costless to, say, find a substitute or to establish what the right course of action to correct the breach is going to be. And so we'll talk a little bit more about incidental damages in class. One more hypothetical for this video, and I just want to pause and give you some real talk about damages. It's numbers, it's calculations, and the only way that you are going to pick up how to calculate these damages and what kind of damage, whether we're talking about expectation, reliance, restitution, makes sense in any given scenario, is to work through lots of damages scenarios. There's lots of resources for doing that. There's CALI exercises, which are great. There is your connected casebook materials, which now are free, and our librarian, Professor Meyer, sent out an email about those this very afternoon. So working through problems is the only way to really get a good handle on how the damages work, right? How do the numbers relate to the scenarios that we are talking about in our cases in class, and what you'll see on my exam, the bar exam, etc. So one more hypothetical before we go. Let's say that you have hired Danny the stable hand to help clean out your stables, and you agree to pay him $500. Now, he's working on the cheap. The actual market rate for his services that he's going to provide you is about $750. Right? So how much value are you expecting to get? Well, you're thinking, I'm getting $250 worth of value beyond what I'm paying for. Right? Let's just do straightforward expectation. Danny doesn't come. What are the direct damages? Well, in part, that depends on whether you paid him up front. Because if you paid him the $500 up front and he doesn't show up, you're going to expect that $500 back plus the $250 of value, right, that you expected to get out of the transaction. So you're going to want $750 from Danny. And that makes sense, because you'll need to take that $750 and turn around and presumably pay it to somebody else to provide those same services. Now, let's say you hadn't paid him up front. Right? You are so far out $0. Right? But you would want $250 in damages, that extra value you expected to receive, again, because you are going to have to turn around, presumably, and pay somebody else $750 if that's the fair market value for the work. And so those are the direct damages in expectation. Now let's talk about consequential damages scenarios. You hired Danny to clean out your stables because you had a potential client coming over the next day to see about boarding her horse in your stables for the next 3 months at $500 a month. Because Danny failed to clean the stables, your stables did not look pristine, the client complained, you lost the client, and thus you lost your expected $1,500 profit, $500 a month for 3 months. And let's assume that Danny knew that that was why you needed him to come today, show up on time, muck out your stables. Right? That's arguably a consequential damage that results from Danny defendant, the stable hand's breach of not showing up. All right, incidental damages. You know that it is critical that you get these stables cleaned before your client shows up. You have to drop everything to go find a replacement for Danny after he tells you he's not cleaning the stables, because you don't want to lose that expected $1,500 profit from the client. You spend an hour rounding up a replacement. You're a busy attorney. You normally bill your clients $300 an hour. So you ask for that time that you could have been working and billing clients as an incidental damage to Danny's breach. Okay, now, you might think, that last one feels a little bit more, speculative maybe. I mean, you didn't have to take the time. You chose to take the time to look for another person to come clean your stables. And so one of the big distinctions between incidental and consequential damages is that some statutes treat them differently, right? And frankly, The consequential damages are the ones that get the most attention because they have the potential to really exponentially increase the amount of expectation damages you're seeking, because you can make arguments about, well, I expected all of these positive things that would earn me money to flow from this service, this action under the contract being performed. The fact that it wasn't performed has led to all of these losses. And so the distinction is meaningful between consequential and incidental damages, and typically consequential damages end up being at least argued for as a much, much greater sum. And we will spend lots of time talking about consequential damages. So take a look again at Hawkins v. McGee and problem 20.3. Think about the two of them in conjunction with each other, and then take a minute to review the Hubbell-Holmes v. Key case and think about how are the parties arguing damages should be calculated in that case. I'll talk to you tomorrow.